Can someone be sanctioned for exercising a right that is recognized to them? The answer in law has never been in doubt. If it is permitted to exercise one's right, it is not permitted to abuse it. Abuse of majority is the application in corporate law of the civil law theory of abuse of rights. The right in question is the voting right of a company's shareholders. Just like in a democracy, the collective decisions of a company are subject to the rule of the majority. But while the majority has the power to decide, it can only do so while respecting the interests of the company and the common interests of all shareholders, including minority shareholders. The right to vote becomes abusive when a decision is made against the company's interests and solely with the aim of benefiting the majority shareholders to the detriment of the minority. The key factor is the breach of equality among the shareholders. Thus, abuse has been recognized in cases where profits are systematically retained without justification based on the company's interests, with the aim of depriving minority shareholders of their financial rights, while the majority shareholders, who are otherwise compensated for management roles or employment contracts, are not financially affected. Conversely, abuse can also come from the minority shareholders. Here again, the exercise of a blocking minority is, in principle, legitimate. However, it can become abusive when the minority shareholders, acting out of self-interest, prevent the adoption of a decision that is essential or even vital for the company. For example, this could involve voting against a capital increase to avoid dissolution or against the extension of a company that has reached its term. The perpetrators of majority or minority abuse can be sanctioned and ordered to pay damages. But it is also necessary to remedy the effects of the abuse itself. In the case of majority abuse, the decision taken can be annulled. In the case of minority abuse, the decision that could not be adopted may be passed through an ad hoc representative appointed by the judge and tasked with voting in place of the minority shareholders.